Hey again, David Phillips, attorney. The question's been asked, can the trustee in Chapter 7 go after things that I may acquire after the bankruptcy's been filed and hopefully discharged and over? The answer to the question is generally no. Things that you get after you file the bankruptcy case would be yours. That could include your wages, money you've earned, and so forth. Maybe you bought something after the filing of the case. Then those are your items. And this falls under the concept of what is property of the bankruptcy estate. When you file a bankruptcy case, an estate is created, and that basically covers anything and everything that you may own. That estate, though, is created on the day that the bankruptcy is filed, and then, of course, anything in the past that you have and have acquired up to that point now is under the supervision of the bankruptcy court. In most cases, you're not going to lose anything because by the time most people file for bankruptcy, they don't have anything above the exemptions that they're entitled to. There are three, though, very specific exceptions to this rule that you need to be aware of. If you inherit something within 180 days of the bankruptcy filing, it is possible that the bankruptcy trustee would want whatever that inheritance might be. Obviously, if it were just a few dollars, it's not going to make any difference. But if it's anything substantial like personal property that's worth a lot of money, real estate, that's always very popular when someone passes on, or maybe just cash money. But any of those things that you become entitled to get after the bankruptcy is filed and within 180 days could potentially end up in the hands of the Chapter 7 trustee. Another exception would be also if you were to become entitled to a property settlement agreement due to a divorce. And the divorce occurs within 180 days of your filing bankruptcy, the trustee can also look into that because it is property of the estate. And in most instances, it probably won't be worth anything that the trustee is interested in, but they do have the opportunity to see if it would be beneficial to take whatever those items are and sell them, and then maybe it would be available for your creditors. The last one would be if you're become entitled to life insurance proceeds. Sometimes that happens. If that occurs within 180 days, meaning the deceased passed within the 180 days of you filing bankruptcy and you are a beneficiary, then those funds would also be available to the Chapter 7 trustee, and then that money used to pay your creditors. That one actually comes up more often than you would think. We see a couple of those each and every year. And that is part of the bankruptcy law, and it is part of the estate in bankruptcy that's created when you file your case. The Chapter 13 trustee also looks at these issues like inheritance and so forth that we've been discussing. There's a major difference there, though. The rules we just went over basically apply for the whole length of your Chapter 13 plan. So that means if you received an inheritance 3 years into your Chapter 13, depending on what we're talking about, how large an inheritance it is, it very well may end up in the hands of the trustee for use to pay your creditors. So a little bit of unfairness there in the Chapter 13 versus the Chapter 7, where you only have the 180-day rule. Under recent court decisions, it appears that the law is pretty much established that the Chapter 13 trustee has access to any of these post-petition acquisitions that you may come into for the length of the Chapter 13 plan. If you have any questions about any of this, inheritance and so forth, please give our offices a call. We do take phone calls Monday through Friday. If you prefer to email us, just go to phillipsbankruptcy.com, go to the contact section, shoot me an email, and I'll try to get right back with you with an answer. Thanks for watching the video.